Just bear with me here. This is the first time we've tried to do this, so we might have some technical difficulties. I'm just going to copy a link here to get going. But basically, we've got a big breaking news story, I guess, as can happen in the Supreme Court. Very rarely is there a medical malpractice case that reaches the United States Supreme Court. And today we have one. And this is kind of a big deal for practitioners in federal court. And I'll explain that in just a second. But here's what you need to know. In medical malpractice cases, you usually bring these in state court. But sometimes, where there is what's called diversity of citizenship, meaning one party is from one state and the other party is from another one, they're diverse, you can bring that medical malpractice case in federal court under what's called diversity jurisdiction. You have this, like we're licensed in Kentucky, Tennessee, and Georgia. It's often the case that people will cross state lines for medical care, especially southern Kentucky into northern middle Tennessee, people coming from Bowling Green, for example, to go to Nashville. In that situation where people are crossing state lines, you might have medical malpractice cases that get brought in federal court. Okay, so what does this mean? The issue is the states, Kentucky, for example, Delaware, which we'll get into in this Berk versus Choy case, the states have enacted these rules related to bringing pre-suit notice, related to bringing medical malpractice cases. And one of those is pre-suit notice, as I was just explaining. And there's another one is called the Affidavit of Merit, or the Certificate of Good Faith, that you have to bring these things before you can bring your lawsuit. You have to hire doctors, you have to send specific letters, notice letters, which are very difficult to do, and people commit malpractice all the time, lawyers do, by doing this incorrectly, and getting cases thrown out because they didn't follow these very technical state rules related to when you can bring a medical malpractice case. So the question is, what happens when you have a federal court case, a diversity jurisdiction case? And before I get into that, I just need to copy the link to this live stream and send it somewhere, so bear with me. Here we go. Stand by, stand by. Okay, so what happens when you bring this case in federal court? Do you have to follow these state rules? Do you have to follow state rules related to pre-suit notice, certificate of good faith, affidavit of merit? And that was the issue in the Supreme Court. Now, how did this case get to the Supreme Court? Well, most of the circuits that had decided this issue, that had looked at this question, for example, Kentucky and Tennessee are in the Sixth Circuit. It's long been the case in the Sixth Circuit that these rules don't apply, that you can bring a medical malpractice case in federal court and you don't have to follow the rules of Tennessee or Kentucky related to certificate of good faith or affidavit of merit, pre-suit notice, etc. What happened in this case, it comes out of the Third Circuit, which is where Delaware is, and the Third Circuit went the other way, and they said that these rules do apply in federal court. So that created what's called a circuit split, and that is why the Supreme Court took this case to resolve the tension between the circuits, right? The Sixth Circuit and the Third Circuit and other circuits had decided this. I believe that the Third Circuit was the only one that went this way, but I could be wrong about that. Okay, so Harold Berk is the plaintiff. The facts of this basic medical malpractice case where he suffers a foot injury and he's suing, saying that they, sorry, let me get to the facts here, where he's suing and saying that they manipulated his foot in a way that was, below the standard of care. But Delaware has this rule, and he didn't follow the rule. Okay, so the question then became the rule about, you know, pre-suit notice and affidavit of merit and all these things. So then the question became, does this rule apply in federal court? Now this is pretty tricky stuff here, okay, because the reason that we have a debate about this at all is something called the Erie Doctrine, which I will get into. But before I do that, I want to just note something here. This is a nearly unanimous opinion delivered by Justice Barrett, who, by the way, before she was on the court, taught civil procedure at Notre Dame Law School. And this is a civil procedure case, okay? So this is very important for injured people injured by malpractice, very important for lawyers who do medical malpractice, but it's not a really fancy, splashy political case, right? This is Civ Pro, okay? And we have this concurring opinion, which is actually longer than the majority opinion by Justice Jackson, who's going to disagree with the analysis of the court, but actually signs on to the larger issue. So the issue is this. In federal court, federal rules of civil procedure apply, right? That's called the Erie Doctrine, and there's various, you know, manifestations of that. So state rules of procedure do not apply in federal court. And the issue really becomes, is this procedural? Is this rule about, you know, you have to get a pre-suit notice, you have to get an affidavit of merit, you have to have evidence for your case, for your med-mal case. You have to have already gone to an expert before you can even file the case. Is that a rule of substance or is that a rule of procedure? And if it is a rule of substance, does it matter? Basically 9-0 or 8-1, the Supreme Court says, look, this is a clear rule of procedure that applies here, because basically what we have is Rule 8 of the Rules of Civil Procedure, and I might be able to show you Rule 8, but basically it governs what is required to initiate your lawsuit. Basically, what is a pleading? What does it have to say? And it doesn't say anything in it about needing evidence. It doesn't say anything in it about having to have an expert to prove your case. It's just a short and plain statement of your claim. Now, it also has to, under this case called Twombly and Iqbal, it has to have, you know, a plausible claim. But a diversity case, medical malpractice, that's not really going to be an issue. So the real issue is, does this pre-suit notice, does this affidavit requirement, expert requirement, apply in federal court? And the answer is no, because it's a simple rule of procedure, right? The Third Circuit held otherwise and said that, look, this is a substantive rule. This is where we're getting a little bit technical. A substantive rule of state law. So typically in a diversity case, you apply federal rules of procedure and state rules of substance. So the defendants in this case say, look, this is a rule of substance, and therefore the state rule applies in federal court, and therefore you throw it out and throw out the case because plaintiff in this case didn't comply. Supreme Court rejects this and says it doesn't actually matter under this Hannah case, and let me get you to the exact quote I want to share. Doesn't actually matter because the rule, there's a conflict here, and the rule of procedure is going to trump the state rule, even if it is substantive, okay? And let me show you that real quick. But this gets into basically the supremacy clause, okay, which is the state cannot make rules that trump the rules promulgated by the federal government, by Congress. And let me get you just to this place. Sorry, I know this is a little bit, you know, wonky because we've not really played with doing live stuff before. But let's get to here. the idea being that even where the state rule is substantive, as it is here, there's no debate actually that this is a substantive state rule, that they're saying, you know, we have merits-based reasons for applying these rules. They say it doesn't really matter under this Hannah case. And I apologize for not being able to find this very cleanly, but we'll get to it. Just bear with me for just 1 second. Okay. Okay, here you go. Let me get you this. It says it's word rejected. Okay. All right. I don't know how well you can see this, but this is basically the crux of this argument. The defendants are arguing that whether a rule is valid requires asking a second question, which is whether the displaced state law is substantive. We rejected that approach 8 decades ago and declined to reconsider it now. So in other words, the substantive nature of a state law makes no difference. To determine whether a rule is valid under the Rules Enabling Act, the only question is whether it really regulates procedure. Rule 8 does, so it governs, and Delaware's affidavit law does not apply in federal court. This is kind of an interesting point, and I'm sorry it took me so long to get to it, to find this little segment, but the idea is that it doesn't even matter, okay, that this is actually a rule of state substance, substantive state law, because it actually does regulate procedure. It governs the manner in which a lawsuit must be brought and what it must say. And those are procedural questions. So Rule 8, the federal rule, applies to that and governs that. And to the extent those things conflict under this Hannah doctrine, which is an offshoot of the Erie doctrine, the federal rule is going to trump, the federal rule is going to control. Okay, so what does this mean for practitioners? Well, let me back up, sorry, I know, one more thing. There's a little bit of a dispute, and as I said, Justice Jackson's, this is the conclusion of the majority opinion. Justice Jackson goes on for, I don't know, another 10 pages, and she's got this whole other angle about it's not actually Rule 8 that governs, it should be Rule 3, because her thing is the way that the Delaware statute, Rule 3 and Rule 12, I should say, because the Delaware statute has this weird angle to it that said the lawsuit cannot be docketed, cannot even be instituted in the first place unless the pre-suit affidavit requirement is met. So she gets hung up on, why are we talking about dismissing a case, the rules relating to that, when we should be talking about what it takes to institute a case. I actually think she might have a better point. There's some back and forth in the footnotes here. There's this sort of banter between Justice Barrett and Justice Jackson about which rule should really have been the crux of the analysis here. Might actually think Justice Jackson has a better argument on that, but it makes no difference. So getting to what I was going to say, which is the question about what does this mean for practitioners? Well, I'll give you an example. We had a case, it was a civil rights case recently in the Sixth Circuit that actually just settled, where we had a denial of medical care in a jail. And I wanted to bring my constitutional claims and did bring constitutional claims. But there was also this sort of fallback, well, even if it's not a civil rights constitutional case, it's still a medical malpractice case. This is still below the standard of care for treating inmates in a jail setting. And I didn't do a pre-suit notice, and I didn't do an expert affidavit, which is a little bit dangerous, but I'm going to explain in just a second why I think it's actually the smarter play for practitioners, I guess. And if you're listening to this and you're a plaintiff who is thinking about hiring a malpractice lawyer, these sorts of things might be important considerations. So, as I said earlier at the top, the Sixth Circuit had long held that these rules don't apply. Tennessee's rule for example, very similar to Delaware's, doesn't apply in federal court because of the conflict, this whole Erie supremacy clause situation. But you still might have a situation where, again, you have a mixed fact pattern that could be constitutional and could be medical malpractice, or maybe it's a slip and fall at a hospital. It's like a premises liability, but it could also be med mal, and you don't really know what it is. If you're in federal court, you don't have to do the pre-suit notice. And the reason also I would say that you shouldn't do it is that because of this, okay, let's think this through. Because the pre-suit notice rules, the affidavit rules don't apply, then similarly, any rules that purport to extend the statute of limitations or the statute of repose, which is how Tennessee's law works, if you send your pre-suit notice, you can extend the statute of limitations. Well, now, if they don't apply in federal court, then you might get in a situation where the extension, sending the notice and relying on the extension, you can't do that anymore, right? Because the extension for the statute of limitations applies to what's required under state law. But if we've just said now under this new Supreme Court case that those laws have no application in federal court, then trying to rely on the extension would be dangerous and risky. So if you have a med mal case, now you could do both. You could, I suppose, send pre-suit notice, get the expert affidavit, and file within the original 1-year statute of limitations. But again, it's dangerous perhaps to think that you can rely on the statute. So what does this mean? This is, we've seen this in defamation cases. For example, there are what's called anti-SLAPP laws that are very similar, that if you bring a defamation suit, the defendant can file an anti-SLAPP lawsuit. I think it stands for strategic lawsuit against public participation or something like that. There's a backlash against defamation suits, and so states have enacted, including Tennessee, California, have enacted these anti-SLAPP laws. They don't apply in federal court, and although some jurisdictions have said they do, this reasoning, I think, will go a long way towards resolving those questions. So I think this decision is going to have some broad impact across other areas of law beyond medical malpractice. I think this is the right opinion. Again, it's not really that controversial, despite this little spat between Justice Jackson and Justice Barrett over which rule we should have been looking at. The result is the same, right? That the law does not apply in federal court. And I think this makes it easier to bring, certainly medical malpractice cases in federal court, and is a lot easier for plaintiffs to not have to, make initial investments in time and money, and also just delays in bringing your case to court. So I think this is a good result. It's important to note that the court is reaffirming that you don't really need evidence initially when you bring your case, and that's true in 1983 civil rights lawsuits. There's a discussion in this case of a case called Leatherman where they rejected that idea. So it's just a long-standing rule. The question might be, is there going to be any sort of federal congressional backlash to this opinion? I certainly hope not. But that's kind of my take on this opinion and why it's important to do this. So I don't see any questions here in the chat. So thanks for bearing with me as I have tried to explain this and see about doing a live video for perhaps the first time. And yeah, as I said, this is a good result for plaintiffs who are bringing diversity jurisdiction cases. And it's not every day that you see a Tennessee medical malpractice case. So thanks so much for watching, and let us know